recognized and left to him in terms of the remedial action itself, not by reference to a general power that he has to second-guess the public protector. The second point, my lady, relates to the stay. The submission by our learned friend, Mr. Maleka, has been that you either implement or seek a review. There is no third option. My lady, that is not correct. The third option involves the court. The submissions of all of my learned friends have been, and are correct, that a review application doesn't stay the implementation of a remedial action. You must first get a court order by the review court setting aside the remedial action, then you're completely excused. But there is an interim position, my lady. There's a position in between implementing and between getting the order of the review court setting aside the remedial action. And that is to get an interim relief that stays the effectiveness of the remedial action. That is what was granted in the former president's case, and that is what we seek in this case. And that is what was granted by Justice Potterell and the other judgments that have been granted. So what the EFF judgment says at paragraph 74, and my lady can look at it. What it says is that remedial action, so it starts off by saying no binding and constitutionally or statutorily sourced decision may be disregarded willy-nilly. It has legal consequences and must be complied with or acted upon. To achieve the opposite outcome lawfully, an order of court would have to be obtained. Now that order of court can take various forms. It can be an order granting you excuse in the interim from complying because there is a pending challenge. Or it could mean an order setting aside actual remedial action. So it mustn't be understood that there are only two extremes. You either comply or you apply successfully to set aside. Otherwise, rights would be completely negated in the middle, where the remedial action is so obviously patently wrong, patently unlawful, but just because you have to implement, you have to carry on implementing. And the only reason in this case that the president said, I can adopt an implementation plan which allows me to await the outcome of the review, was because the remedial action itself allowed him that discretion, not because he is exercising an outside discretion. Just on this point, our learned friend said this discretion issue was dreamt up in the founding affidavit. It was never referred to in the correspondence. But it may not have been referred by name, but it's pointed out what powers are left to the president. And the letter, my lady, that starts at page 174 of the papers, and specifically at 175, which my learned friend read, the second paragraph that you read at page 175 says this: you appear to have concluded that I am refusing to act on your direction to take appropriate disciplinary action against Minister Godai. My emphasis. This is not the case. In terms of your direction, it is for me to determine what is appropriate disciplinary action to take. That is a discretion left to him. That's precisely what the president is saying in his letter. And he repeats that in his founding affidavit, rightly so, because that is his case. That he's left the discretion, and it's considered, it's common cause that remedial action doesn't fix a date by which the disciplinary action must be taken. And it doesn't prescribe a form that disciplinary action must be taken. And that distinguishes completely, 100%, from the EFF position. In the EFF judgment, the public protector, they chose to prescribe the form of the action to be taken. And she said it must be a reprimand. And the court upheld that and said reprimand. But here she chose to leave it to the president. It's her choice. And we submit that she did so in line with the duty to respect the executive powers of the president. That's what she did. She could have chosen a different remedial action. She didn't. She did choose it differently in the rogue unit case where she stipulated the time frame. That's different. When she's made a choice, she's made a choice. And she makes a final decision. She's found to sufficient. She can't come back and reinterpret her remedial action. So that is the backdrop of the case, my lady. And it must be understood to be distinct from the SABC case and distinct from the EFF case. In the EFF case, you had a president who deliberately and by choice disregarded the remedial action of the public protector and chose to follow the advice of parallel processes. That's not what the president has done here. And it's with great respect an exaggeration to compare the conduct of the current president with the conduct of the president in the EFF judgment. And it's important at this stage, just talking about generalities, that it's also highly unfair and highly unfounded, not supported by any fact, to suggest that the president has insulted the office of the public protector. He hasn't done so in his correspondence, he hasn't done so in his founding affidavits, he hasn't done so even in public statements that are released by by his office. And in his founding affidavit, my lady, and especially in his reply, he was very astute to avoid the unnecessary personal attacks by the public protector that he is friends with the minister, and for that reason one can never expect that he will discharge his constitutional obligations. His answer was, this case raises simple questions of law. He is not going to engage in irrelevancies. And that is how we have, representing him, approached this matter. That is, the court must decide the question of law that arise on the facts that are established on the papers. Now, my lady, I want to move to the more general submissions my learned friend for the EFF submitted and said they form a backdrop against which the case must be decided. And that by that he referred to the constitutional provisions. He referred, my lady, to section 83. I don't want to take my lady to section 83 again. I simply identify other provisions of the Constitution which are important, because the Constitution must be read holistically. The Constitution is not in conflict with itself. The Constitution must always be read consistently with itself. And the first section, my lady, is section 1C, the supremacy of the rule of law, my lady, the supremacy of the Constitution and the rule of law. First. And then section 34, which guarantees the right of access to court, which Minister Gordhan has exercised. And then again, section 38 of the Constitution, which says a litigant must be given appropriate remedy, and the Constitutional Court has said that remedy must be an effective remedy. Those provisions are important because when one looks at the conduct of the president in saying, I will await the outcome of the review application, are there constitutional imperatives which he is complying with? Of course they are. I referred to the Gambling Board judgment, not for the reasons my learned friend for the EFF said. I said my lady must have regard to paragraphs 49 to paragraph 52, where the SCA says a functionary who's an administrator or an executive functionary must not take precipitative conduct which denudes effective constitutional relief which is sought by a litigant. Here the president is quite aware that Minister Gordhan is challenging the very basis on which he has to take remedial action, the very foundation of the remedial action. And this, the Constitutional Court in the EFF and this court through Justice Mkhwebane made it very clear that the public protector is subject to scrutiny by the courts. She is not unassailable, and in consequence, her remedial action and findings must be allowed to be scrutinized by the court before adverse consequences are visited upon individuals. And this is all the president is trying to do. He is paying respect to the judiciary, he's paying respect to the obligation to ensure that he doesn't by conduct denude the relief that ultimately Minister Gordhan might obtain. Our learned friends posit what that relief might look like, and that it may become irrelevant to the remedial action. My lady, that's the kind of arguments we tried to present to Justice Mkhwebane. He said, but what happens to the commission if it is instituted and it is found to have been unlawfully instituted? And we said that the review court has wide remedial powers. In its just and equitable remedial powers, it might decide that the commission will continue. And he said, but That's just one possibility of what the review court might do. There are a host of other possibilities. One of them might be to set aside the commission as a whole and say it's unlawfully instituted, it cannot continue. And for that reason, he said in the paragraphs, I referred my lady earlier, that I received no satisfactory answer from the applicant's counsel, and dare I submit for the public protector, we tried our bit to provide the answers, and he said there is no answer because the discretion of the review court is wide. But I need to protect the ability of that review court to decide the questions of law and to afford appropriate remedy at the appropriate time. What is the hurry, he said, if the commission can be appointed in 10 months' time when the review is concluded? We ask the same, my lady. They have not suggested to you what the hurry is. That contract which happened 10 years ago must be disciplined now. It cannot wait. The answering affidavits are filed on the 12th of August 2019. There is no reason why this court will not afford the parties an expedited review to avoid any alleged damage to the rule of law and to the public protector office. My lady, if these arguments about damage to the public protector merely by stay provisions were correct, then all of the other stay would have been opposed by the public protector because they would all result in the same outcome, because they are going to delay the implementation of remedial action. But Justice Potter was quite right. It is incorrect because the mere fact that you stay the implementation of remedial action to allow for the judicial process strengthens the rule of law, which is foundational to the operations of the Public Protector's Office. So we submit, my lady, that there is nothing there to be said. And I've dealt with the issue of discretion, and I've referred to the letter that the President's always been has always acted on the basis that he's left discretion by the remedial action which the Public Protector so clearly and definitively and deliberately chosen. Yes. And may I, against that backdrop, move to the stay application, my lady? There are three fundamental concessions which the Public Protector rightly made, and we submit those should be dispositive of this case, of the issue about misalignment, and added to that is a submission made by an friend for the EFF. The first is they say this is competent relief. That was the Malena trend for the Public Protector. You can bring it to court, so you can come and ask for a stay. And the President could bring it. So they accept that the President has legal standing to seek the kind of stay that he asks. Our learned friend for the EFF says the President is the target of the remedial action. So we had said, well, the target is Minister Godan, the President is the implementer. He puts it very highly, he says the President is the target. Then if he's the target, clearly he's affected directly by the review application. Where's the misalignment? Because if he's the target here, if the review court says the findings are set aside, there is no lawful basis for the President to take disciplinary action against the Public Protector. If the court says some of them are upheld, others are not upheld, the nature of that disciplinary action might change. In the range that our learned friend says the President has, he'll be informed by those findings as to what the change is. So the only real ground about misalignment remains this notion that because you are not the applicant for review, you are not entitled to get interim relief. My lady, we refer to the Air Road Express judgment, not for the suggestion that the facts are similar to the present, but to point out the general power that this court has and which it must so jealously guard in order to protect against injustice and hardship. And we pointed out how injustice and hardship will work out in this case, and nothing has been suggested other than to suggest that these two parties might sit at tea at the union buildings and have a fireside chat. But they don't comprehend in that submission, my lady, that the serious nature of the findings made by the public protector. And it's important to have regard to those findings, my lady, at page 120 of the papers. The reason why she says take disciplinary action, she says at 7.1.1, to take note of the findings in this report insofar as they related to the erstwhile Minister of Finance, Mr. Gordhan, and to take appropriate disciplinary action against him for failing to uphold the values and principles of public administration entrenched in Section 195 of the Constitution, and the duty conferred on members of the Cabinet in terms of Section 92(3)(a) of the Constitution to act in accordance with the Constitution. My lady, in the case involving the President on impeachment, which my learned friend Mr. Mbofu was one of the main aggressors when I was a defenseless counsel on the other side. My lady, the question was posed by the court to all of us. Can you ever find that a breach of a constitutional duty is not serious enough to warrant impeachment? And I said, as counsel making a submission to the court, I cannot make that contention. My lady, to say that if this finding at 7.1.1 is upheld by the review court, all the President will have to do is have a fireside chat and tea with the Minister. It really is not to be serious about the seriousness of the findings of the public protector. If she is serious that these findings are serious contraventions of the Constitution, then clearly the disciplinary action would have to match the nature of the contravention. And that, my lady, can only be taken lawfully and rationally by the President once the review court has determined that this finding is upheld. And just on this misalignment, so I've referred to Air Road Express. Our learned friends haven't said that that general power doesn't exist. All our learned friends says that they've thrown out the challenge for us to go find a case which is on all fours with this. Of course, I mean, the public protector hasn't been around that long or presented reports of this kind for that long that we would have precedent. But this is why we have courts. The Air Road Express, the SCA tells you that you have wide powers to prevent an injustice. And may I refer you to a provision of the Constitution which has not been taken into account so far. And that is Section 173 of the Constitution. Because that track the kind of general power which the Air Road Express refers to. Section 173 of the Constitution refers to the inherent power of the court. It says the Constitutional Court, the Supreme Court of Appeal, and High Courts have the inherent power to protect and regulate their own process and to develop the common law, taking into account the interests of justice. And you recall Justice Makume saying, where you're seeking a stay, the overall consideration is interest of justice. But what's important about Section 173, my lady, is that you have proceedings in this court in which there is a review, there are review proceedings in which the foundation of the remedial action is called into question. And the extent of the powers of the President to take disciplinary action are called into question. Those matters will be decided by the court. Now you are asked by the President to stay the obligation to implement the remedial action pending the outcome of that review application. Our learned friend says you have no power because it is not Minister Gordhan asking you, but you have an inherent power here to regulate your own process. So you can say, in order to protect rights that are clearly implicated here, you can grant an order that allows for proper ventilation and determination of issues that arise in the review application whilst the implementation of the remedial action awaits the outcome. That's in a sense, in effect, what Justice Makume did, was to do precisely that. So this court has wide powers, and we haven't been provided with any authority that is to the contrary. All we are told is that you haven't showed us an example that is on all fours with this. But they have also not showed us an example that is on all fours with this, which says the court can't do what we ask. So, my lady, but we're pointing you to the authorities that say you have general powers. The court has general powers to prevent an illegality. It's a matter of form here, because the President is a party in the review. we're told that the president is the target of the remedial action, and that remedial action is called into question by the review court. And it doesn't help our learned friends to argue that, but it's impossible in this day, in this life that we live, that another court will say that the president has all wide range of disciplinary powers. My lady, there are many. In the case of my vote counts, there is a good quotation in the minority judgment about a very, very old case which talks about that and I'm going to paraphrase, not exactly, but the road to litigation is littered with closed and shut cases which were lost. There is no such a thing as a closed and shut case. So the fact that there is debate about the extent of the president's powers is a debate which the review court must determine, and so much as well in relation to the findings. The review court must determine. And the approach of Justice Mkhwebane is the appropriate approach that this court must determine. This court is not called upon on an interim basis, agent court, to determine that the president is incorrect. He has powers to take any disciplinary action of any kind, all kinds, against Minister Bodan. That's a matter that a court must determine, having received argument directly, specifically directed at that question, and the court properly assisted to make a determination. It is a weighty constitutional issue because it provides guidance to the president for the future on how he can deal with his ministers. So it is not a matter that the court must just take lightly on the very broad and general submission that it can never be that a court is going to say you don't have a power to hold a disciplinary inquiry in the classic sense, or that Section 92 is very clear. It's not clear. It doesn't talk about disciplinary action. It talks about appointing and dismissing. It doesn't talk about anything in between. And the fact that the Constitutional Court approved a reprimand doesn't suggest that it means you can also hold a disciplinary inquiry where there are charges and you hold an inquiry and follow a process, which is very much one of the options that the president might have. My lord, my lady, in that score, I must point out the fact that our learned friends for the public protector are wrong in the reading of the president's founding affairs. You recall, my lady, they said the president is very clear here that he's got powers. He's not in doubt. And they referred you to page 27 of the, they referred you to page 20, I think it's paragraph 28. Yes, paragraph 28 is at page 21. Now, I asked my lady to read that paragraph first against the backdrop of the implementation plan that the president submitted to the public protector. Because in there, he made it very clear that there are two issues in the review. First is the basis of the remedial action, and secondly is the competence of the remedial action. And I'm in doubt, the court will guide me on what power I have in the review, and secondly, whether there is a lawful basis to take remedial action. Now, if you read 28.1, it starts at 28, says, a question that follows is it appropriate for the president to decide what is appropriate disciplinary action in the face of an ongoing review? I'm advised and submit that it is not. That's the position it takes. 28.1, the disciplinary action that the president takes must be rational. It cannot ignore the existence of the review application. For instance, the actions available to the president might, doesn't say they range, might range from delivering a reprimand to the minister, suspending or even removing him from cabinet in the extreme as a consequence of the findings of remedial action. The appropriateness of the countless and varied options will be informed by the court's findings in the review application, and he refers to the report itself. And then he says also at paragraph 43.3.4, page 30, my lady, he says, that's where he deals with balance of convenience. He says at page 9, paragraph 83 of the founding papers and in other parts of the founding papers in the review application, the minister challenges the public protector's remedial action on the basis that it imposes incompetent, inappropriate, and improper remedial action on inter alia the president. The court does not have to express a view on this matter for present purposes, in line with Justice Mkhwebane's judgment. However, the challenge goes to the heart of the question whether the president can in fact implement the remedial action. Taking a decision on this matter at this stage would undermine certain aspects of the review application and render it moot and academic. This is an undesirable result. It will also not accord sufficient respect to the role of the courts to first determine the legal and factual issues that arise in the review application. The President is not saying those issues have no merit. I know that I have a power. And it's important also about the emotive submissions that were made, that in the President's paragraph where he refers to the challenge about the competence of the remedial action, he doesn't couple it with all the other, what my learned friend Mr. Mkhwebane submitted as insulting allegations by Minister Bodan. He limits himself to the legal question. So it is unfair and unjustified in the extreme to then say the President has insulted the public protector. And so we submit again that prospects of success, my lady, are a consideration, but they are not decisive in a matter of this kind. And we urge, my lady, to follow the judgment of Justice Makume, which is binding, that it is for the review court to decide those weighty constitutional matters, but it's clearly in the interest of justice not to prejudge and prevent the review court from determining those properly, my lady. And we have not had any criticism about the judgment of Justice Makume. We've had a lot of criticism against the judgment of Justice Potro, whereas Justice Makume was dealing with a stay relief which is very similar to this, set out the test as he says applies. The only difference is that the President would apply in that case for the review But we say that is not a determinative matter given the broad powers of the court. Then, my lady, can I just deal with my learned friend for the EFF suggested, sorry, not EFF, my learned friend for the public protector suggested that the modern law now sets 7 requirements for interim relief. And he added fraud and corruption and all the rest of it. My lady, that's not correct. The law still sets 4 requirements for interim relief. There are a number of considerations within those requirements, but they remain 4. You must show a prima facie right, reasonable apprehension of my lady. This is the Tuhalo test. In fact, the Constitutional Court endorsed the Tuhalo test and simply updated it. In other words, saying, for balance of convenience, you must also take into account separation of powers. But it doesn't say that you now suddenly have 7 requirements. That is just not correct. And the judgment of Justice Potter deals with all of those requirements correctly. And now, my learned friend for the EFF said, and I'm still in the state contention, says, well, the President has an obligation to uphold unity in the Republic. And he says he's failed because he's litigating against the public protector. First, he ignores the history of the correspondence between the parties. But he says in his submission, I might have misrepresented his submission, but my lady has a note of what he said, and I don't intend to misrepresent. It's just my best recollection. But he said this, my lady, in order to comply with his constitutional obligations, including maintaining unity, the President should have decided on the remedial action and told the minister he's going to take it and let the minister challenge him in court. In other words, cause a litigation between the President and the minister so the minister on the one hand against the President and the public protector. My lady, that is not a solution because it too just adds to the litany of litigation. It is not an option. And if that is one option, there is also another reasonable option, which is to await the outcome of the review application. And, my lady, his response was Section 41 of the Constitution applies, that organs of state must avoid litigation. We accept it does apply. But the very SABC judgment that my learned friend referred to in the High Court and going to the SCA, part of the SABC's explanation for why it hadn't yet complied with the remedial action was it wanted to engage the public protector. And the courts made very clear that there's no room for engagement. You must comply or get a court order to excuse you from implementation. So this whole notion about cooperative governance and the president could have done more, it flies in the face of the principle that has been emphasized over and over again by the public protector and our learned friends, that the only option is implement or get a court order. And we are here to get a court order to stay pending a review application, and we are told we should be kicked out of court. My lady, I deal with the other requirements for interim relief. We've dealt with these requirements in our heads of argument, and I don't want to belabor the point. But it's important, my lady, to deal with the question of the prima facie right, because in our respectful submission, our learned friends completely, especially our learned friend for the EFF, have said that we've come to court to assert a right to protect the review right of Minister Gordhan. And that's the right that we assert. And Outer tells us that there is no such a right. That is incorrect, my lady. And I isolate my learned friend for the EFF because it is common cause between the public protector and us that the question of prima facie right is not an issue. On the papers, my learned friend might have argued many other things, but the papers say it's common cause. But I accept that the common cause point might be that we're entitled to come to court, and that might be the end of the common cause. For the sake of progress, yes. The concession was for the sake of progress, but we submit that the concession for the sake of progress is in line with the law. So the court can rest assured that that concession was well made. But what is the right that we assert and we submit in our heads? My lady can turn to a paragraph, page 19 of our heads of argument. And this is in line with what the president says in the correspondence and in the papers, that he says, I've been left the discretion to decide the manner and the timing and form of the disciplinary action. I must be allowed to do so, taking into account the outcome of the review application, because that's the only time that I can decide rationally on an appropriate disciplinary action. And the right, we say, is this, at page 19, paragraph 54, we make the first submission that where the right asserted in a claim for interim interdict is sourced from the Constitution, it would be redundant to inquire whether the right exists, because it exists, and we refer to authorities for that. Paragraph 55, we say, in this case, it cannot be contested that the President has the executive power to appoint and remove the minister under Section 91(2) of the Constitution. The minister's review application will determine whether that power encompasses a power to take disciplinary action against the minister as though he were his employer. That implicates procedural fairness questions which may invite the courts to intrude into the domain of the executive. The remedial action taken interferes with the President's exercise of executive powers under Section 91(2) of the Constitution, in that the disciplinary action to be taken might involve removing the minister from the cabinet. But this depends on what the review court determines to be the lawful reach of the President's powers in this regard, and whether the findings of the public protector will stand and provide a lawful basis for taking any disciplinary action against the minister. The President is entitled, indeed duty-bound, to assert that he must be afforded the space and opportunity to act lawfully and rationally in taking disciplinary action against the minister. He is elected that this requires him to show respect and deference to the courts and await the outcome of the minister's review application. And we submit further, as I submitted earlier in the morning, where the public protector had submitted in writing before Portal J that the concerns of the President given the minister's review application are well founded. It is plain that he has made out a right, even if open to doubt, that the taking of the disciplinary action ought to await the outcome of the minister's review application. This will vindicate the importance of the role of the judiciary as arbiter of the requirements of the rule of law and the rule of law itself. So the President is saying, preserve my executive powers, and in doing so will vindicate the rule of law and will also preserve the rights to obtain effective relief on the part of Minister Gordhan. He's not just saying, I seek relief in order to preserve Minister Gordhan's right to seek a review. And we haven't got an answer to the submissions we made. And that is on prima facie right. And we deal with other requirements for interim interdict at page 32 of our heads of argument. Our learned friend for the EFF said there is no allegation about the apprehension of harm in the president's reasonable apprehension of harm that might be irreparable in the president's founding affidavit. He does, of course, deal with it at page 29, paragraph 43.2, where he deals with reasonable apprehension of harm. And he says, the president has been accused by the public protector of acting contemptuously, bordering on being in breach of his constitutional obligations. This has serious reputational and legal ramifications for the president and the rule of law. The negative potential impact that this has on the constitutional status of the public protector cannot be gainsaid. The president has stated that he has elected, as he was entitled to await the finalization of the review to take an appropriate decision. This is to avoid taking an irrational and unreasonable decision which is acceptable to legal challenge whilst the review application is ongoing. So the harm there is the rule of law quite clearly and allowing unjust outcomes when there is a clear pending review application. And there is no way to repair that when Minister Godhan succeeds in his review application. It's quite plain. And that is why we think it was advisable too for the public protector to concede that also for the sake of progress, but in line with legal precedent and legal requirements. Then the question about the balance of convenience, we've addressed that in our heads. Alternative remedy, we also address, my lady, page 32. There's clearly, and I've said that there's no engagement here. And balance of convenience, my lady, the only question here that has been raised is the separation of powers. But of course, separation of powers here, I didn't say it's double, I said it cuts both ways. In other words, where separation of powers works one way, it discourages the courts from giving an interim relief which will intrude into the exercise, into the separation of powers. But where it cuts both ways, it's neutral as a consideration. So it doesn't discourage the court from intruding. So it is not, in this case, a strong consideration that will count against a grant of interim relief. But if one looks at balance of convenience in relation to Minister Godhan, it's quite clear that he's going to suffer injustice if he succeeds in the review, and he can make submissions for himself. But we reply. But may I say this? Our learned friends said in their submissions, and rightly, that when one looks at the harm that must be balanced in balance of convenience, you're not limited to the harm to the individual, you must look at the harm to the public interest. Now, the public interest here affects Minister Godhan also, because it is in the public interest for us to deny him an effective remedy ultimately, inconsistently with the constitutional requirements. Of course not. So the president could not ignore that. And he says so in his correspondence and in his founding affidavit. He says he can't render the relief that ultimately Minister Godhan might get empty. It must be an effective remedy, and our constitution requires that. So, my lady, that is the question on stay, my lady, our submissions on stay. And we submit that on the test in the judgment by Justice Mkhwebane, which has not been overturned by any court, this stay application ought to be granted. And also, my lady, in that case, the public protector had accepted that the interest of justice is an overriding consideration. And I referred, my lady, to paragraph 29 of that judgment, where the concession was made. Responsibly so, because that is the position, my lady. And there are numerous cases of review. One of those cases, my lady, is Mediclinic. I can't recall the citation, maybe unreported judgment, which went to the SCA. And the question there was an argument that interim relief can't be granted because prospects of success were not strong. And the court said, I'm faced only with the founding affidavit. How am I to decide prospects of success? I don't know what the answers are going to be. I don't know what the review record is going to be. So, although the prospects of success may be a consideration, it cannot be decisive in those circumstances. My lady might express prima facie views about prospects in circumstances where you're only presented with the review application, the record is still going to come, there's still going to be answers, replies, heads of argument. The complexion might change completely, 180 degrees. So, my lady, we submit that on the facts that are before you, my lady, and on the binding authorities of this court, my lady should grant the stay, my lady. And if my lady finds that there are difficult issues to traverse in relation to the declaratory order, which we submit, there aren't. Because, my lady, the relief has not been properly presented or rather understood by our learned friends. And that's part of the reason why a lot of the argument made was that because no disciplinary action has yet been taken, it is clear that you can't grant the declaratory relief. But that is to misunderstand the declaratory relief. The declaratory relief is not saying the court must find that the president has taken disciplinary action. What it says is that, in paragraph 2, it is declared that the President of the Republic of South Africa has complied with the remedial action of the Public Protector, arising out of the investigation and reporting to allegations of maladministration and impropriety in the approval of Mr. Pile's early retirement with full pension benefits and subsequent retention by the South African Revenue Service, bearing reference number that, in that the President has, 1, in compliance with paragraph 7.1.1 of the report, noted the adverse findings made in the report against the second respondent. It's common cause that the court can give a tick to that. 2, within 30 days of the issuing of the report, and in compliance with paragraph 8.1 of the report, submitted an implementation plan to the Public Protector, indicating how the remedial action in 7.1.1 of the report will be implemented. Here our submission is simple. The example my learned friend Mr. Mkhwebane gave about how one must understand that was very opposite. He said, if the order of this court says, submit an affidavit for my approval, do you comply with that order, or are you in contempt of that order? If you submit an affidavit, but the court doesn't approve. My lady, the obligation is to submit for approval. You submit for approval. The obligation or discretion to approve is on the Public Protector side. But one must understand the legal obligation on the part of the Public Protector. The legal obligation is not to refuse approval arbitrarily. She must not unreasonably withhold approval. Now, we have referred to the judgment of Potroche and the Gambling Board judgment to support the proposition that it was entirely lawful and consistent with the Constitution for the President to say, appropriate response to me in formulating my implementation plan is to respect the role of the judiciary to determine the issues that arise in the review application and to await the outcome of that review application. Our learned friend said, but which law is she referring to in that paragraph? Paragraph 42 is a naked statement of law, unsupported by any judgments. But what they haven't showed you is any authority that goes against that. All they said, my lady, is that contrast that against the obligation to implement. That obligation continues and doesn't excuse you. But of course, it depends on what that obligation on its terms says. That obligation says you decide the timing and the form, because it doesn't prescribe the timing and the form. So you're well within your rights when you decide that I will await the outcome of the review application. That conduct is not unreasonable, and it can never with respect breach Section 237 of the Constitution. Our learned friend for the EFF says, well, if you are waiting the outcome of the review application, you're not acting without delay, it's unreasonable. It doesn't follow. It depends on whether there is a justifiable basis for that delay. Because delays in this court are condoned day in and day out, because the Constitution doesn't prohibit delay per se, it prohibits unreasonable delay. And here, Justice Potter correctly, and there is no wrong about that. The fact that she doesn't refer to authority is simply that the proposition is trite. The Gambling Board case makes very clear, respect, don't denude rights. constitutional rights of litigants. So here, the conduct of the President to submit an implementation plan which awaits the outcome of the review application is first in line with the law, because it's not prohibited either by the remedial action, the wording of the remedial action, or by the Constitution. But more significantly, my lady, and we've said it ad nauseum, is in line with the submission, the very submission the public protector made in this court in the matter before Portal Jail. They made that, and we've referred to the submissions they've made. They haven't told the court why they must be entitled to walk away from those submissions, because those are the submissions of a serious Chapter 9 constitutional body, and we are entitled to accept that when she says, this is my understanding of the law, that is her understanding of the law, and she doesn't chop and change as and when exigencies change, my lady. And that is the same point about Justice Makumi and the concession in that judgment that the interest of justice is an overall consideration. And then today we are faced with an argument that we must allege fraud, my lady. We don't have to allege fraud. So we submit, my lady, that in fact this application is capable of succeeding on all of the relief that is sought. And paragraph 3, my lady, is a simple paragraph. Simply says, if my lady accepts that paragraph 2.1 and paragraph 2.2 of the notice of motion must be granted, there is still a step, which is the taking of the remedial action after the review is finalized, and that must be regulated. And the President says, I'll take it within 30 days. And all he wants is to achieve certainty that there is a court order that he must comply with. Now, learned friends for the public protector criticize us for the fact that we say, and I think the EFFs too, that we say in the notice of motion, the taking of the disciplinary action, it must always be, my lady must always be conscious of the way in which the two terms have been conflated by our learned friends, between remedial action and disciplinary action. We accept that the taking of appropriate remedial action resides with the public protector. But the taking of disciplinary action here, appropriate disciplinary action, the public protector has given to the President, and is left him to decide the timing and the form. So those must always be distinguished, because there was an argument which conflates the two. But I was here, my lady, that they say there is something wrong in us asking that the taking of the disciplinary action must await the final determination of the review, including appeals. My lady, even if we had not added including appeals, when you say in an order pending the final determination of a matter, there is clear authority that includes determination by appeals. So that's very clear. Even if we had not said it, it's there. And the court is not bound to give the order in the terms in which we have formulated. So if the court is somehow uncertain about including that part, it simply gets taken out, as the court did in the President Zuma's case, where the relief was what the court considered to be appropriate in the circumstances, but having the effect of suspending the obligation to implement the remedial action. But my lady, more significantly, the case that my learned friend Mr. Malika and I were involved in, we were on the receiving end in the SABC case. My learned friend acted for the Minister of Communications, and I acted for the SABC, and another learned friend acted for Mr. Mkhwebane. My lady, Mr. Mkhwebane ultimately was dismissed from the SABC. So the remedial action took effect ultimately. And after reviews and appeals, he was allowed to exercise his Section 34 rights. But ultimately, he was dismissed, and the rule of law was vindicated, and the office of the public protector was strengthened. And for that reason, the parties never even tried to go knock on the door of the Constitutional Court to say, give us yet another appeal. They realized, even if you tried, you're not going to be successful there, my lady. So it doesn't mean that the only time when the remedy will be effective is if parties are denied their Section 34 rights. The Constitution requires that all rights must be protected, but the office must be vindicated. And the reviews can be expedited, and there's no this suggestion that, my lady, this review is going to take 5 years, and the President will go into the sunset, and so will the Minister go down, and they'll never be disciplined. It's all speculative. A period of 5 years in office there's no guarantee that this review will end in 5 years. There are many reviews here, even the review by the former president into the remedial action about the all-important commission of inquiry. This court instituted a full bench, made a decision. He tried to knock on other doors. The doors were closed. We now have a commission of inquiry. The rule of law is vindicated. The office of the public protector, and may I say here, the incumbent then, the office has been strengthened, my lady. We submit with great respect that it is when the public protector engages in opposing unmeritoriously clear orders that must be granted and are granted in the ordinary course, that question marks are raised by the public about the office, rightly or wrongly. I'm not suggesting rightly, but that is when questions are raised, and that is when confidence may be adversely affected. But when the public protector acts responsibly, as she does in so many numerous cases where she agrees to these kinds of orders, the office is indeed strengthened, my lady, and the rule of law and the Constitution are vindicated. And so we submit, my lady, that if my lady can grant all relief. The alternative is also obviously the alternative. If the first three are granted, the alternative doesn't come into play. But if my lady, if the declarator is granted, then we don't need the alternative relief. But if the court is not with us on the declarator, in paragraph 3, it simply gives the stay mandate. Yes, yes. So all the President says at paragraph 2.2 is that he submitted a plan for her approval. We accept that she hasn't approved, but we're submitting that she has unreasonably withheld approval on the authority of the judgment of Justice Bottrill and the Campaign Board judgment. My learned friends say that this is a review by the back door. It's not a review, my lady. I'm suggesting that the approval, the lack of approval doesn't stand in the way of the declarator, because that refusal to approve is not consistent with the law. It's an approval that is unreasonably withheld. We're just asking for a declarator. My lady, the form of the relief we seek mustn't avoid the court being able to deal with the substance of what we're asking. So, my lady, we submit that in closing let me just go back. Oh, yes. Then there's I must just say more conclusively about association with everything that the minister has said in his review papers, that at page 274 of the President's reply document, he says at paragraph 49, there is also, paragraph 49, page 274. The President says there is also no alignment with the allegations contained in the Minister's founding papers in the review. So it's clearly denied, and there is no contrary allegation to counter. There's no factual allegation other than all these political cases. I mean, one must accept that this case is heard in a climate that is highly politically charged. But the court doesn't decide politics; it decides only the case on the facts in the court. As the SCA reminded all of us in the National Director of Public Prosecutions versus the former president, in the case coming from the Pietermaritzburg High Court regarding the judgment of Nichols in jail, that courts must not drag themselves into all conspiracies and political insinuations, must decide the law, decide the case based on the facts of the law. So we submit, my lady, that all of the submissions we've made, there is no basis to dismiss the application. It must be granted, either the first or the second form of relief. And the costs are really in good hands, my lady. Those are submissions for the President. As the court pleases.
My lady, if there's going to be a reply, it's only subject to our right to reply to it. the usual 5 minutes, my lady.
Where she makes clear that she's looking at those letters in order to determine the normal practice by the public protector and how that has not been followed here. The second issue is just this question around Minister Gordon's papers being insulting to the public protector. And I don't know.
My lady, I'm asking just to interrupt. I need to excuse my junior because he's catching a flight to Cape Town for court tomorrow. He's got it. May he be excused?
I thought you were the one who's going to. Oh. That's why I didn't write you. Did they? Oh, that's good.
Indeed, my lady, but the point that is made in our argument today is that this is all somehow an insult, and it is not in fact appropriate to be in the founding papers of a review. The point is simply that it is a substantive ground review. By a ulterior purpose for which the public protector exercised her powers is a substantive ground review. And for us to close our eyes to the fact that Minister Gordon is the subject of 4 investigations by this public protector, that she is the only person against whom she opposes a stay of implementation of remedial action. To claim that there is some legal basis to this opposition, as opposed to raising questions about whether she's exercising her powers for legitimate purposes. The question is to say, why is she here opposing this remedial action, where she is not, for example, in this very case here, insisting that SARS implements the remedial action in the following paragraphs of the report. So it's just to say that there is simply no basis for the argument made to you this afternoon that this is all gratuitous insult. It unfortunately is a case where law and politics are existing side by side, where it has to be taken into account
unacceptable. They're not in the papers.
That is all that I need to address in response to my letter. Thank you, Madam.
My lady, I was not going to reply until those last words. Well, I'll say literally two things in 1 minute, my lady. One is, it doesn't matter how many investigations the public protector has against Mr. Gordhan. All investigations are subject of complaints. And it's not the public protector who solicits those complaints. So if Mr. Gordhan doesn't want to be investigated, he must stop breaking the law and being complained about. But the only thing I want to say, my lady, is, and this is really one sentence, at our page 2 of our heads, paragraph 3, it provides the full answer to this entire case. It's the passage that my learned friend Mr. Malika read from paragraph 73 of the EFF case. It covers everything Mr. Manechi said and everything my learned friend Ms. Leroux said. And it is this, I'll read it slowly. When remedial action is binding, compliance is not optional. Whatever the reservations the affected party might have about its fairness, appropriateness, or lawfulness, even lawfulness, right? When remedial action is binding, compliance is not optional. Whatever reservations the affected party might have about its fairness, appropriateness, or lawfulness. That's what the Constitutional Court of this country has said. Neither the President nor Mr. Gordhan can change that law by saying, well, what if they review this, that, and the other? Assume that they had reservations about appropriateness, lawfulness, and even fairness. They must still comply. It is not optional. That's court business. That's the law of the land.
There's a court business. Thank you, Minister.
Mr. Court, please. Say we appreciate it. To talk for us.
Likewise, my lady, we'd like to thank you, my lady, together with your staff for overstaying. For staying over. We're indebted to you, lady.
Thank you. Thank you. Thank you for staying with us. Judgment is reserved. Hopefully I will hand down the judgment on Thursday, the 8th of August 2019. Should there be any problems?
That's
Mr.
the
Court, please.
But I'll endeavor to hand it down on
on the 13th.
Mr. Court, please.
the court agent.
Okay, guys, thank you very much.
Thank you. It's always been
Yeah.
I really appreciate it. Keep the political. No. It's not our case.
Yeah, cool. Just call me in the afternoon.